Hello, everybody. This is Nate, the lawyer, coming at you again. Let me get on the screen. Hopefully, everybody can hear me. What's going on, people? Are we good? Today, I have a special guest for you, somebody out of the annals of Discord. Welcome, Agrippa. What's
Hey,
up,
Nate.
Agrippa?
How are you, mate? You good?
Yeah, I'm all right. How you doing, bro?
Yeah, pretty busy this week, but good. Been a busy week.
Ah, that's good. Good times. Good times. Hold on, that's still. Make sure this is off. All right, good. So obviously we had the secret evidence bomb drop today, right? Secret
Yeah,
evidence.
yeah. Wow, it was such a fucking like a fart in a spacesuit, really, wasn't it?
So what did you think? Was it what you expected?
Uh, I no longer have any expectations. I have to say in this case, it certainly wasn't something that sat me on my heels and made me think, "Wow, I've got this all wrong. This is a killer blow. This is going to change the whole annals of North Carolina commercial law as we know it." It seemed like a bit of a slap with a wet lettuce leaf.
Hold on one second. The bridge thing got an echo. Do you guys still hear my echo? No. Yeah, Agrippa, do you have headphones on?
Hang on, let me
Because
just check.
because
Yeah, I
because
do.
I hear the echo when I unmute you. Before when I mute you, there's no echo.
Test,
When I
test. Is that better?
yeah. There's no
Okay,
echo now.
cool.
All right, let me get these super chats out the way. Michael, is that Maritz? Love listening to your show. Thank you so much, and thanks for the support. Thanks for the $5 super chat. I hope you enjoy it. Bit of an echo. Thank you, Secret Squirrel. Thank you, Secret Squirrel. We
Yeah,
just
should be
fixed that
fixed
up.
now.
Yes, thank you. Better. All right, perfect. Good. So, just so everyone knows, because obviously I have I've been growing in subscribers like crazy, so I got to give the 2 minute, the elevator pitch of the Non-Seq show. Okay, so for all you fans who don't know this, for all you people who do know this, I know it's going to be like, damn, he's got to explain it again. But yes, I've gotten like 6,000 new subscribers in the past like 4 weeks. So, I'm getting like 1,000 a week. So people aren't going to know what I'm talking about. So I got to just lay it out. The Non-Seq show was a show here on YouTube. It had two hosts, Steve McRae and Kyle Curtis. Now, the show went pretty big, right? Right, Agrippa, and went up to what?
Yeah,
30,000 subs, right?
30, 33 or 32,000 subs. Yeah, it was
32,000 subs.
head projecting nicely.
Now, it was one of those, shows that, it was one of those, they had flat earthers on. It was one of those type of things. They went to a lot of the fringe stuff, and it became pretty popular. I think a lot of that had to do with Kyle and the way he managed the show, and a lot of the stuff that he did concerning, the way, the look, the feel of the show, because it was a very well produced show. Eventually there was a falling out, and Kyle, who had access to all the funds and all the money, disappeared, right? He just gone. So he fired Steve, and Steve got upset, and he was like, well, hold on, we were 50-50 partners in this deal. Kyle said they weren't 50-50 partners. Kyle said he was going to pay Steve. Kyle said he had an attorney. Kyle said he had an accountant. All those things happened to be lies. He did not pay Steve. He did not have an attorney. He did not have an accountant. And then Steve, at the end, winded up suing Kyle in North Carolina. And he sued Kyle for control of the show. So for the court to find that it was a business, that he was a partner, and that he would get 50-50 control of the show and administrative rights. So guess what? We hear on YouTube, everybody's always threatening to sue. This lawsuit actually happened. It was bankrolled by Steve's longtime friend Ruhef, who, from Australia. So they hired an attorney in North Carolina and sued Kyle. One of the big issue that's coming up with this case is that during the lawsuit, Steve got a default judgment. So Steve effectively won the case right off the bat, right? He got a default judgment. Kyle didn't show up to the court case. Supposedly he was in a bad place, quote unquote, bad place. Didn't show up to the lawsuit, didn't respond. And the judge awarded Steve a default judgment. So during the default judgment phase, right, where now there's an order for Kyle to turn over everything to Steve, Kyle then puts a motion in saying that he was not served properly. Now, obviously, when we talk about service of process is that thing that happens where when you want to start a lawsuit, you have to notify the defendant that they're being sued so they can come and defend themselves. And if you don't do that in the way that it's stated in the statute, then your case can be thrown out. It could be, they call it set aside, right? And you have to start from scratch. So Kyle claimed that he wasn't served properly. And his biggest contention with not being served properly was the fact that Steve and his lawyer sent the summons and complaint to Kyle's old address, right? So Kyle wasn't living at the place they sent it to. Now, that happened to be the big problem, is that Kyle wasn't living at the place they sent the documents to, which seemed to be a violation of the procedures in North Carolina. Now, Steve's and Ruhef's argument is that Kyle's mom is his agent. That's one argument they have. And the second one is that Kyle actually still lived there. And the third one is that you can serve an old address in North Carolina. The old address in North Carolina, that doesn't work. They're saying Kyle's mom was not his agent. And what was the last one? They were, Kyle is saying his mom was his agent. Yeah. And Kyle has submitted documents, rent statements, and all this other stuff to show that he wasn't lived there. Like he has a bank receipt, he has a lease agreement, he has bank records, he has tax records, all to show that he wasn't living at his mom's address when the paperwork in. So that's the issue now, and that's going to be decided next week, Friday. We're going to do the live stream. I've already gotten the credentials from the court, so I've contacted the court. They sent me the credentials and everything already, the passcode, the link, and everything. So Friday at 10 o'clock. Dragnot's birthday. I'm calling it Dragnot's birthday. It's the worst day in the world for Steve, maybe. So we're gonna do an open hangout. Yeah, we're gonna just do an open hangout. Whoever wants to come in, and we're gonna watch it together and just go through it. We'll see how the judge questions everyone, and it's interesting because I'm not sure if the guy, I believe he gave me the link for a lawyer, because the credentials that he gave me allows me to interact with everybody. So, perfect. So I have to kind of I can unmute. He's like, you got to make sure you keep yourself on mute. So I don't know if that's for everybody. So I'm sitting back like, yo, I just want to watch. I don't want to.
I'll jump in.
Yeah, I don't want to. You're wrong. You're on that. No. Just I'd rather not be able to.
Let's run a kangaroo court.
Yeah, I'd rather not be able to.
This fucking judge ever even read Draper?
Ask him if he's an atheist.
Yeah,
he's an atheist. Yeah, it's going to be crazy. But that's Friday at 10 a.m. So if you guys will be here, we're probably going to start a little earlier. Hopefully, I see Drag in the chat. Drag, hopefully, you'll show up so we can watch the shit show together. It may be about 2-3. So expect to spend some time. We're talking about 2-3 hours of your time, maybe just looking at it, and then we get to see the judge and we get to see what's going on. So the link, I think the link is already out, but I'll put the link in the description again for those of you who want to watch that. But that's definitely coming down. So again, if you guys want to watch it with us live, I think we have enough room for maybe. I'm going to limit it to like 9 people, so we're not going to be too many people in here. But I think it's going to be a fun. Even if you're in the side chat, we're going to be able to watch it live. I wonder what the questions are going to be for Steve. And even for Kyle, because they both may be questions. So this is what it's going to be. So now you've gotten the background. I've talked for about 10 minutes, letting you know what we're talking about here when it comes to the non-sec. And have I missed out anything?
No, I think you got it all, mate. I think you got it all.
All right. So what are we doing here today? Well, we now have a hearing scheduled. This hearing is really the meat and potatoes. This is the hearing is high stakes. If the plaintiff, Steve McRae, wins, he has effectively won the case, right? He has to effectively win. He has effectively won the case. So, hold on, make sure my mic is the right mic.
Happy though?
If he wins this motion, yeah.
Okay, there's winning the case, as in the default stands.
Yes, that's what I'm talking about.
Is that winning the case though?
Yes.
And you've got the issues of damages.
Well, damages is a different issue, right? Yeah. But he's been found liable, and now it's about how much he has to pay. So yes, he would. If this motion goes against Kyle, Steve would have won, and Kyle would have to turn over, and that he has an order to turn over everything.
Otherwise, he'll be in contempt.
Yes, and otherwise he has to do so. That's what's on the line for Steve. Steve has essentially won, and that will be erased if he loses this. And then with Kyle Kyle has contempt. Kyle is on the hook for possibly contempt. He has a lot that's riding on this too. He would have lost the case. So if Kyle wins, then everything starts from scratch, right? Steve's default judgment is thrown out and everything starts from scratch. So all that Steve screaming that he won, that goes all away. And one thing a lot of people, nobody's talking about, is that Kyle did turn over some things to Steve.
Yeah.
And those things that he turned over, Steve will now be legally obligated to turn back over to Kyle. So like when you go to the Non-Seq website, how it's Steve and Cheshire on the front, they have to turn all that stuff back over to Kyle if they lose. They lose. So this will be a interesting little thing. I bet you this. If Kyle wants to be an asshole, let's say if he does win on next week Friday, he should go on to Non-Seq and start streaming. I won. I got it back, right?
He better bloody invite us.
Oh yeah, he's gonna invite us. So now you guys know what the stakes are. The stakes are huge. The stakes are huge. This hearing is really it, right? The winner has won. Kyle, if Kyle wins though, Ruhef has already said that he's willing to spend more money for a trial, and I think he's saying it's going to cost about $20,000 for the trial. He supposes so. Ruhef has said if they lose, they are going for it, and they are going to trial. Period. Kyle, I'm not sure if he has the money or if people are going to. Do you think people are still going to give to his crowd source, or with crowdfunding for the lawsuit?
Yeah, I think they probably will. Yeah, look, I mean, he's only had one dip at it, so I think he might have one more at it. Yeah, I think people will probably give.
Yeah. So you've looked at this more recent filing. What do you think? Now, for those of you who don't know, I forgot. I got to introduce the filing. This filing that you're going to see on the screen now is Steve. With Steve's side, wasn't really allowed to reply to the last filing because it's first you got the motion, then the defendant replies, then the plaintiff. Then then you have the response. Then you have the rebuttal, and that's supposed to be it. But in this particular case, it seems like Steve is trying to sneak in a little rebuttal, and he's sneaking it in through a supplemental affidavit. Now, Ruhef has told us about this secret evidence. He teased this to us last time we spoke to him, right? What did you say about the secret evidence? It was going to be,
this was really going to change the dynamics of the whole case and blow everything open. And he's been on Twitter sort of saying the same sort of thing. This is critical. This will show Kyle up, and yeah, okay. We waited in anticipation.
Yeah, so this evidence that we're about to supposedly show you now was supposed to be game changing, right? It's supposed to change the case. It's supposed to be the judge supposed to look at this and says Kyle was served properly. It's over, right? So I don't know if it shows this, but we're about to look at it right now to see, right? Here we go. The secret evidence. Will this even count? Since it was filed so late, that's the problem. It may not count. The judge may not even look at this, to be honest with you, because the judge may just simply say like, "Hey, this is, your filing is kind of wild affidavit. These things have to be authenticated. How do I know these things are accurate? That type of thing." But
I guess whilst we're talking about the filing component, and maybe for some of the audience that have just recently joined you, there's been a litany of mistakes by Steve's lawyers. Outside of they can't get an address right. 3 times now they've got addresses wrong.
They can never get that address right.
But the other component is these filings, and we saw the first affidavit submitted by Steve's lawyer, which was the junior, and then we sat and looked at the response back from the judge to that lawyer, and I think you and Drag did a hangout on it, just sort of laughing, going, this is not good when a judge actually goes back to the lawyer and says, "Hey fella, when you submit an affidavit, you need to put some other bits and pieces around it, like evidence."
Yeah.
Then we had the next affidavit filed, which was he's going to stream on the channel. He's using the Twitter account. You need to stop him. It's all terrible. It's all bad. None of which happened. Then we had the judge come out to both parties and say, "Hey, Kyle, you don't comply with my judgment. You're going to end up doing some jail time. And hey, Steve, by the way, you fuck me about and use the court in the wrong manner. You're going to answer to me as well." Now then we had the last one before this was Kyle, see, we've sent it to an address that Kyle said he lived at, but he doesn't live there, therefore Kyle's lying. And now we've got this affidavit, which, to be quite frank, is in the same vein as the other 3 or 4. It's disjointed. It doesn't make sense. It's poorly based in any sort of real evidence.
Well, you know what? Let's stop teasing it to death. We've teased this to death, right? We're 15 minutes in and teased you. It's like crazy with it, right? So let's just look at it. Let's just go over it. Let's see what the secret evidence is. So here we go. Secret evidence revealed. Boom. Let me put this on screen. All right. So this is supposedly the supplemental affidavit of Stephen McRae in opposition to defendant's amended motion to set aside. So we go over the particulars. He's over the age of 18, why he's putting this in, the reason why, and all this other stuff. So I'm not going to read through all this, but this is it. Now, I'm going to start at number 5. In my previous affidavit, I also provided evidence of instances where Mr. Curtis represented in public forums that he was served with the complaint, that he understood the allegations of the complaint, and that he failed to appear in the case, even after telling people he had hired an attorney to appear on his behalf. Mr. Curtis has not disputed these instances in any of his affidavits. Now, just to start here, this is a technical issue, right? So it doesn't matter if Kyle eventually got the papers, right? This is about how he got the papers. Was he personally served? Did they serve to his house? Like, this is about the process of how he got the papers. So if he eventually got the papers, it doesn't matter. Go ahead.
But the other thing is that that's all really good, Steve, but your first affidavit wasn't challenged at all because he got a default judgment. He didn't turn up.
Yeah.
So why are you telling the judge this?
Yeah, this is saying that, it's trying to make it seem like
he's mischievous and he's lying and he's deceitful.
But this, the only thing this tells me is that he knew about the lawsuit. Is that they're saying we know that he knew about the lawsuit, right? And now they're saying he's been served with the complaint. So maybe they have some evidence that says that he's been served with the complaint. So, Mr. Cater.
Again, it comes back to what we talked about with Ruhif Live before. This sitting on evidence and withholding evidence because you're going to come in at the 10th hour and lay this evidence on the court live on Zoom. What? If there's evidence that they've got, why haven't they submitted it?
Well, this is it. This is it. And that's what we were asking before. They should have submitted this with this last. This is kind of trial by ambush, which the courts pretty much frown upon. But again, I understand why they're trying to do it because they want the element of surprise. They want the last word. So let's see what happens. Mr. Curtis states that his mother, Susan Curtis, was not authorized to accept service on his behalf. He does not dispute that she did sign for it on his behalf. Mrs. Curtis stated in her affidavit that she signed for the certified mail addressed to Mr. Curtis. So why would you admit this? I think this kills your case, right? Because you're saying she was an agent. And he says, he wasn't an agent.
When have ever done that? When's Kyle ever admitted that?
No, well, he says Mr. Curtis states that his mother was not an authorized agent accepted the service, right? That's true. That's what he says. But then it says he does not dispute that she did sign for it on his behalf. But what does that matter if she's not an agent? So
Joe
what
does
does it matter?
I'm not going to dispute Joe Bloggs signed for it because Joe Bloggs' name's on it.
I don't know. Are we missing something here, chat? The fact, and so let's say he sent it to the grocery. They sent the papers to a grocery store, and the clerk at the grocery store signed for it. Kyle says he wasn't my agent. So here it says, well, the grocery store clerk signed for it on his behalf.
Yeah,
I don't see how this.
Yeah, he didn't challenge that was the grocery store's clerk. Well, yeah, it was. What do you want me to challenge here?
Yeah, I don't get it. But okay, well, it's it's interesting, whatever. Mr. Curtis further states that he did not receive notice of the lawsuit from his mother, and he first obtained a copy of the complaint several months later. Okay, so he's saying that he didn't receive notice of the lawsuit and he got a copy of it several months later. So now we're talking about time frames, right? Because eventually he had to get notice from his mother because he got the papers. So now we're talking about when. So is it for the first month? Is it a couple of weeks? Is it initially when she got the papers? There's a time frame. Oh. And one thing I want to put myself on the screen. One thing that people have to understand about service of process. Service of process is important because it starts a clock ticking. When you are served with the papers, you have a certain amount of time to respond. And if you don't respond in that time period, you can get a default judgment against you. So that's why the process of service is very important, because it starts the clock on you to respond. So if you're served improperly and you don't have, and that time frame runs out, then you didn't have a chance to respond. So that's what we're talking about here. Him having the statutory amount of time to prepare and prepare an appropriate defense to the lawsuit because he was served properly. So I don't understand why they don't. It seems like Steve and them don't understand that piece of it. You know what I mean?
Yeah, they seem to be making an argument that because Kyle eventually got the documents, whichever way he got them, that's enough for service.
Yeah, but let's say if you get it, I think in North Carolina it's 30 days. Let's say you get it on the 31st day, and you finally get the documents. Well, then you effectively couldn't even, you're too late anyway. You know what I'm saying? So that's what I think that they're missing. The fact that you got the documents doesn't matter. Service, because it's really the time frame issue.
Well,
so here we go.
I read somewhere on Twitter that both Steve and Cheshire had emailed Kyle the documents. Again, not proper service.
Yeah, but emailing the documents means nothing. The reason why the reason why it's statutory, and the reason why it's so particular,
30 days or 21 days,
because they have to know exactly when you got it, that you actually got it, and that we can start ticking the clock. So you can do it. So you can respond. So here it is. The complaint was served on August 30th, 2019, over a year ago. It's crazy, right? This has been going on for over a year. A few weeks later, on September 23rd, 2019, so we're talking about almost a month later, Mr. Curtis participated in a group chat on Discord, which is an online text voice. So they explain to us what Discord is. This discussion was open to the public and took place well before the deadline for Mr. Curtis Mr. Curtis respond had passed. So
to the public?
Well, hold on. But this is not well before the time. If you're talking about August 30th, if you're talking about 30 days. So from this September 23rd date, he may just have a week left. He doesn't get the full 30 days. He may have just had a week.
Yeah.
If this is accurate, I don't even know if this is accurate. So now they try to do this authentication real quick. A true and accurate recorded copy of the session can be found here. So that language in there is he's trying to authenticate it, saying, okay, this is a true and accurate recording. So they put the link there. And it says at the 1951 mark, the interviewer stated to Mr. Curtis. Now, this was hog tie, right?
Yep, it was. Yes.
As I understand it, you were served papers on a suit from Steve against you. And I'm curious if you have legal representation, or if either of you, or if either have or are intending to respond to it. Now, his answer is Mr. Curtis did not deny that he had received the complaint. Well, not denying that you received the complaint, that doesn't mean anything, right? All right, he didn't. He did. If he says yes, I received it, I would say, okay, this is good. Sure. But him not denying it, he said instead, he said, of course, I responded to the lawsuit. Not responding to it would be a dumb decision. So I think you can infer that he may have gotten in. Of course, I responded to the lawsuit. So Kyle then continues to say, so that's going to be taking place in a couple of weeks. There is seems to be an unorderable. I am going to speak to it anymore aside from that, but yet that it will be happening. We are set to rumble. Later in this same discussion at about 44:20, Mr. Curtis appears to have contradicted his contention concerning his residence. Okay. When he was asked if he had moved, Mr. Curtis said, no, I spent an audible. Me and my boyfriend live in different cities. So I guess if I'm gone from home more than 2 weeks, I have moved. Okay. So this was on September 23rd. So is this enough? Now I'll ask for a quick chat poll. Do you guys think this is enough to overcome the evidence that Kyle has? So Kyle has, what evidence does Kyle have that he moved? Agrippa.
Well, Kyle's got a telephone bill, he's got a bank statement, he's got a tax filing of some sort of registration, he's got an affidavit from his mother and an affidavit from his lawyer and the rent agreement. or showing he'd moved prior to August the 30th.
So rental agreement, tax document, credit card statement, and a lease agreement showing that he had moved. Yep. And they are saying this, what they're putting up here, this line that he said, no, I spent blank, blank, blank. Me and my boyfriend live in different cities, so I guess if I'm gone from my home more than 2 weeks, more than twice a week, I moved. I don't think. I
don't know what even context that's in, to be quite honest.
Yeah, I just don't think this is enough.
Is he talking about his new property that his boyfriend is in? What's home?
Again,
what's he defining as home?
This is, and let's just be clear. I don't think he's making this legal declaration while legally, it could be the context of the conversation. But if somebody brings you evidence like, here's my rent receipt, here's a lease agreement, then it's like the guy lived there. You know what I'm saying? The guy moved,
Well, of course, I poked Ruhif on Twitter yesterday whenever this thing came out and just said, is that it? I thought you were going to actually do some real PI work and come up with something really, really serious, saying, here we've got his actual bank statement showing, his actual bank and his actual record showing he hadn't moved.
Yeah, something. Documentary evidence.
Yeah.
When you have, listen, people, I'm just going to be honest with you. When you have documentary evidence, right, that you live someplace, that overcomes you saying I don't live there, right? That's the key, right? If all your evidence shows that you lived at this place and you say I never lived there, the documentary evidence is what the court's going to rely on. Your bank statement, your lease agreement. If you didn't live there, then you did a hell of an impression of somebody who did. Yeah. Does that make sense?
It does. Interesting super chat from Super Squirrel. Squirrel.
You read it out.
It's possible Kyle wasn't comfortable telling people his personal business on Discord. And
of course,
that's secret. That's a very valid point. A lot of people don't want their private information of their personal life out there and about there. And he's sitting on a Discord with people he really doesn't know that were pretty antagonistic, if I remember the time, because I was in that Discord.
And that address is all out there for everybody to see. Yeah. So yeah. Hey, baby. My daughter is bothering me. What you want? Come on over here. Come tell the people what you want, baby. Let me get this super chat from the Geek Room, Jill. I think she is tired now. Go ahead, finish what you're doing. So we now have a very, very, very interesting proposition here. They think that this should be enough to convince the judge that Kyle actually lived with his mom. I don't think we're there. Maybe there may be some other secret evidence within this document that convinces me, but let's just be clear. It's just that this is not it, right? This is just not it. All right, so let's go on to this next line. Let me take this off so people can see. Okay. So I'm not going to play this one either. But they have, because they have the relevant clips here. On October 6th, 3 days after the entry for default judgment is filed. So now you got the default judgment filed. 3 days later, Mr. Curtis participated in another Discord conversation. So just to show you how scumbaggish these people are, they're going around recording conversations with people. You know what I'm saying? That's a scumbag thing to do. Now, it's like I would almost feel embarrassed that people are out here doing this.
Yeah, this is what you're doing. You're going around. I mean, let's face it. Discord is a public environment, but by invitation of the Discord owner. You don't just log on to Discord. You've got to be invited to join.
Yeah. I just think this is I think this is insane. It's insane.
Unethical peaches. It's just unethical peaches.
Yeah. They're the most ethical people in the world who are secretly recording all their conversations. Yeah. It's what type of life are they living over there? $5 from Who's Your Buddy Steve's rising tides seems to be capsizing his boat instead of raising it. They could have $5. Yeah. I don't understand. Well, maybe there may be more here. Let's not prejudge it. Maybe there may be more here. This conversation referenced in my prior. So he now is going back to a conversation that Kyle participated on Discord and he referenced it before. Yep. I don't know why he had to put this in here. Again, maybe he just wants to let the judge know. But at 4:30 in this recording, discussing his failure to respond. Mr. Curtis states, I missed the filing deadline because of something going on with my side, not Steve's. Now, I think this is actually pretty good. So it's my fault, but it's going to be appealed. Now, this, I think, is something. I do think this is something, and I'll tell you why. I think this is something because it throws doubt into two things. Number one, it does make it seem like he did not only receive the papers, but he intentionally didn't respond, right? And he does make this admission, if this is authenticated, that it was his fault, not Steve's fault. And this is sometimes why you shouldn't be speaking in public, because this statement may be just out of context, but I think it's enough to make the judge think, like, what do you, when you said it was not Steve's fault and it was your fault, what the hell did you mean by that?
Yeah.
Because right now you're saying it's Steve's fault, right? It's Steve's fault. He sent to the wrong address. But that's not what you said before. Do you understand what I mean by that, Agrippa?
I do, but again, I would just say, look, I misspoke. I was in an open forum. You know, I was being asked a lot of questions at the time. It was a really pressured time. That's not what I meant to say.
Or you just go back to the documentary evidence.
Yeah.
Okay, well, but he sent it to the wrong address, right?
Yeah.
You go back. but I do think this now opens up a little conversation, and this may be the word for the wise. When you're in litigation, you don't go around talking in public about the litigation, because these statements. Now, I hate teaching law on a fly like this, because without going through it. But for those of you who don't know, we'll talk about hearsay real quick. Now, there is hearsay is technically an out-of-court statement offered for the truth of the matter asserted. What does that mean? That means that means any statements made outside of court that you're trying to present into court has to overcome the hearsay rule. Let me give a quick example would be, let's say I have Agrippa on the stand and I ask Agrippa on the date in question, was it raining outside? And Agrippa says, Bob told me it was raining outside. Well, that would be hearsay because Bob is not in court. So it's an out of court statement. And Agrippa's telling us what Bob told him. So that would not be allowed in court, right?
Yeah.
We don't. Bob has to come to court and say what he saw, and it's not the telephone game through Agrippa. But if it changes, if I ask Agrippa, well, why didn't you go outside, Agrippa? And Agrippa says, I didn't go outside because Bob told me it was raining. Well, that would be allowed because whether it was raining or not is immaterial. Yeah, it's about whether Agrippa thought it was raining and why he didn't go outside. So that's the difference between hearsay that's allowed in court and hearsay that's not allowed in court. Now, in this instance, this is hearsay. This is hearsay, right? These statements are out-of-court statements made by Kyle, and they're trying to offer it to show the truth of the matter asserted, that Kyle was actually not served properly. That Kyle made these statements. But there's an exception to the hearsay rule called the party-opponent admission. So if you're a party to the lawsuit, these statements can come in because you can defend it. You as the party can say, I didn't mean that, or this out of context. So the statements that you make as a party to the lawsuit overcome the hearsay exception. And I think every jurisdiction are allowed in. So that's why in most legal cases, in most cases, your attorney is going to tell you don't say anything in public, because those statements that you are made can be held against you in court because they would be considered party opponent admissions. And that's what's going to happen with these particular admissions here that Kyle is making. Anything that he says that's damaging are going to be let in based on this particular concept in law. I'm sorry, I know I went a lot into that. If I confuse you all, look up the hearsay rule, right? That's what it is.
No, I think that's worthwhile because it gives people the background into how these types of statements are used, and reinforces that fact. Just shut the fuck up when you're involved in a law court. You don't talk to anyone.
Hey, and listen, don't forget, I'm a fake lawyer. Don't forget, they always say I'm a fake lawyer. So, it is what it is. Tatted Jedi, $5. Thanks for the $5 super chat. Would you recommend not getting a lawyer from a strip mall? Agrippa is a punt. He's a serious YouTube guest. Can Agrippa sing Evo Russian music?
That's exactly right. Look, Nate went from 6,000 to 10,000 subs. Funny, just after I was on his show.
That's true. That's true.
That's true, isn't it? Yeah.
I had you and Rue have fun, so Rue is going to think is going to think the thing. Thanks, Nate. I'm not here to learn anything for FFF. Thank you, Secret Squirrel. but
surely the defense of all of this, Nate, realistically, all this stuff that's happening in a Discord server and the public statements, he's not under oath. He's not under affidavit. This is I spoke out of place. I spoke out of place.
But the thing is that the issue is not explaining it, because I'll tell you this, for all my clients, I tell them to shut the F up. And the reason why I tell them to shut the F up, because when you're explaining, you're losing, right? Sure. If I got to put you on the stand so you can explain some crap you said before, we're losing, right? We're losing because people have already made their conceptions, and now whatever you said, they're going to think it's BS to overcome what you would, the mistake, right? Even if it's in context. So that's why we tell you, keep your mouth shut, because if the person who's explaining is the person who's losing. That's not true in all cases, but the majority of the time, I want you to explain yourself. I don't want to be explaining anything. Steve, when you said you sent it to the wrong address, what did that mean?
Yeah.
He's got to explain that, not me. So let's move on with the document. All right. Oops. Let me put this a little bigger so people can see it. So you don't believe this is such a big deal, but I do think this is a hit for Kyle. I think there's something that he may have to, that he may be at. I can see the judge asking him about that. So when you said it wasn't, this wasn't on your side, it wasn't Steve's fault, it was your fault. What did you mean by that? If it's your fault, then default good, right? This could get to that point.
Yeah.
And you don't want to be in front of a judge fumbling about explaining what I really meant, Yeah. Well, when you said this, did you mean it or did you not? Obviously, this has to be authenticated. If this isn't authenticated, we still have an authentication problem with these statements and recordings, because Steve wasn't there. He didn't record them. Who recorded them? How were they recorded? Like, all this stuff has to be kind of taken into account. So I don't know if they're going to be able to record it, but I mean, because if I were Kyle's attorney, I'd be saying, I want to know who recorded this, right?
Yeah.
You can't just have a blanket recording and just say, here's a recording that we found from somebody. Who recorded it? When did they record it? I would try to almost get them to dox the person who recorded this.
Absolutely.
Right?
You better tell me. I want to see the original. I want the original hard drive.
Yeah. But I don't think it's going to get to that nebulous, because again, it's going to come to the fact of where did you send the papers. So now we got at 1557. So at 3:57, at the 1557 marks, I'm about to say 3:57 because I'm in military time, but at 1557, Kyle states, what I did was, in the original papers that I was served, there was an attachment part. Okay, so this now he's saying in the original papers that he was served, there was an attachment part. So now he's describing the papers. I do think this is now interesting, but this is after, if you remember this though, this is after the default judgment was in.
Yep.
So when he says this, what I did is, in the original papers that I was served, we don't know if he got those papers after this default judgment or before. I had to fill out where, messed up on the procedural issue with that. Then I filed on Friday with the clerk of the court. Mr. Curtis, of course, had not filed anything with the clerk. So here, I don't know if this statement, it does make it seem like he did get the papers, but it doesn't tell us when. And if he's saying this 2 days after the default was put in, let me turn that off. If he's saying that 2 days after the default was put in, then it doesn't matter, because even if he got the papers, he wasn't able to, he didn't get time to respond to it, right?
Yeah, it could have been any time he received it. And how did he receive it? From whom?
And by Kyle saying he was served papers doesn't mean he was legally served papers. You know what I mean?
It comes back to the technical foul thing, doesn't it?
Yeah, because it's like me saying I was. If I were to ask anybody, even in chat, what are the service of process rules in your own state, you would probably not know. And if I say, what was the service of process rules in North Carolina for Kyle, he doesn't know. Matter of fact, his lawyer doesn't know, right? His lawyer's all messed up on it.
Yeah.
So him saying I was served is not him saying I was technically served under North Carolina law based on the statute, right? I was served some papers.
Yep.
What does that mean? When he was served, how it was served, was it served properly? That's what he's saying now. It went to the wrong address. So I don't know if this is, I don't know. This just hasn't convinced me that this secret evidence moves the needle. It does have some I think issues in it, but this doesn't
do it. All it's saying to me, and I'll play the devil's advocate here, and try and defend this. All it's saying to me is he eventually got the papers. That's it. He eventually got the papers.
And if he got the papers, that doesn't mean anything. Him eventually getting the papers doesn't mean anything because there's actual notice. Him getting the papers eventually means nothing because if this is correct, he technically could have gotten it after the default was in. And what does that mean? He eventually got the papers, so that means the default should stand. He got it after the default was put in. The reason why you want to get the papers early to him in a particular amount of time so he can respond. If think about this. This is why I think this piece is bad. This evidence shows he got the papers, but it doesn't show that he got the papers before the default was entered. Matter of fact, it shows that he's talking about getting the papers after the default.
Yeah.
So what? That's the reason why we're here. He wasn't served properly. I don't know. But I just might be a crazy, what do they say, non-lawyer who just reads this stuff. I don't know. It just doesn't make sense to me. Finally, on January 20th, 2020, Mr. Curtis participated in a YouTube interview, which he discussed the case in some detail. The interview is now available online and can be found here. So they have the interview, and I think they have, no, it's not a timestamp, but at the 1 hour, 10 minute, and 44-second mark in the interview, Mr. Curtis states that he made a mistake and didn't handle things the right way. Okay. And I mean, it's been shown now, but I didn't show up to court. I lied about having an attorney. Okay. That was continuing in the case, in the case. I don't understand what this is supposed to show. He made a mistake in handling things the right way. I mean, it's been shown now, but I didn't show up to court and I lied about having an attorney. That was continuing in the case. Okay, so he lied about having an attorney. He didn't show up. But how does this mean whether the documents are served to the right place?
It's the poisoning the well stuff, isn't it?
Yeah, but like the issue here is whether the documents are served in the right place. So whether I'm trying to understand how this statement about him making mistakes, he didn't handle it the right way. If you sent the document to his mom's house or to the wrong address, this doesn't matter, right?
It doesn't matter. How he handled it is all it's reinforcing is he was pro se and didn't know what the fuck he was doing.
Yeah, I understand what they're trying to say, and I want to be fair. I understand
I get it too.
They're trying to say he's playing a game.
Yeah.
But how does this matter
if the documents weren't served correctly?
If the documents weren't served correctly. Yeah, he handled it the wrong way. Essentially, their argument is eventually he got the documents and he didn't do anything. Well, eventually he got the documents if he didn't serve the person properly. So what, he got the documents? You throw him on the floor. And eventually somebody saw his name on it and say, hey, is this you? And he got the documents. That's not proper service. You can't just argue. I don't know. Maybe there's more here. Let's read through it. At the 1 minute, 14-second mark, Mr. Curtis states about the court case that he, quote, didn't want to deal with anything that was going on. And that's why he did not show up. Okay, so he didn't show up, right? How does that
again go back
change the fact that he wasn't served properly?
None of this does.
Because let's say he got the documents 20 days in and then goes and shows up to court and says, I wasn't served properly. That's the same thing that would happen, a year later, him saying I wasn't served properly. I still don't understand the fact that he didn't show up. The fact that he says I didn't want to show up or whatever. How does this change the facts?
I think the objective here is really to try and put as much information about Kyle's character and past actions in front of the judge to say, hey, this guy can't be trusted. Nothing that comes out of this guy can be trusted because he keeps chopping and changing his story all the time. Having said that, how many times did I think one of your first two or the second or third video about this saga, you're sort of saying, Steve, hold my money, don't hold my money. Steve, hold my money. I never said to hold money. Steve, please hold my money. Both of these idiots have been out contradicting themselves every time they open their mouth. So, what weight do you put on any of this?
Yeah, if the question is whether he was served properly and the documents were sent to the wrong address, which we know here, and they've admitted here, right? Sent to the wrong address, he didn't sign for it, somebody else who signed for it. How does any of this matter to that conclusion, right? That he was not served properly. Only thing they're arguing is that he eventually got the papers and he chose not to show up. That's fine, right? Because if you're not served properly, you don't have to show up. The requirement is you have to show up if you're served properly.
Yeah, you technically haven't got the papers.
So no matter how you get the papers after that, if they didn't serve you properly, you are not required to show up. So the fact that he said I didn't show up, that's fine because he can show that he wasn't served properly. Again, I'm trying to look at it in the best possible light, but I'm trying to understand the end game for this. At the 1 minute, 20 minute, 1 minute, 1 hour, 20 minute, 24 seconds, Mr. Curtis states, if I could go back, I would have absolutely not just, blown it away and shown up like I was supposed to. Okay. If he could go back, but it's still the situation where even if I didn't show up, there was a default judgment declared. He's not been able to prove his side of the damages.
So this must be after the default judgment he's talking.
This is all after the default judgment. This is all after the default.
So how does this help them in any way, shape, or form?
I'm trying to understand because, all right, let's say all this is true, right? That he says, if I could go back, I would have absolutely not just shown up. If the papers weren't served properly and he showed up, he would be making the same argument back then, right? They sent it to the wrong address. But the fact of the matter is the only thing that requires Kyle to show up, right? Am I making this point clear, though? The thing that requires Kyle to show up to the court is the fact that he's served properly. If he's not served properly, he's not required to show up. So him saying that, Kyle chose not to show up, that's fine because he wasn't required to do so because you didn't serve him properly. That's the issue here, right? Am I making sense? Because I may not be making sense.
You are. You're making sense. No, that's fine.
People in the chat, am I making sense? People are saying that they lose me. You guys lost me?
No.
Is it buffering? I don't know. It seems clear over here to us.
Yeah.
Well, so for the people in the chat, let me know. Is it Maya says she gets it. Yeah. It's just like, if you don't serve me properly, I don't have to show up. So if I don't show up, you can't now say, damn, you didn't show up
yeah.
because I served you improperly. Yeah, you're right. You didn't show up. That's just the way it goes. So, all right. So this is what he's saying here. If he could go back, all right, Kyle says if he can go back, he would afford it earlier. Fine. But that's because he wasn't required to show up. Last one, Mr. Curtis does not at any point in the interview complain that he did not receive a copy until several months later, as he states in his affidavit.
Oh, you're kidding me. I mean, really? I didn't have that second cup of coffee either. I really wanted to have it.
Listen, several days ago, I did X.
Yeah.
Am I talking about 7? Am I talking about 5? Am I talking about 3? It's these terms of art are used all the time, and I honestly feel underwhelmed by this secret evidence, right? I feel underwhelmed by the secret evidence. Just Mr. Curtis did not at any point in the interview complain that he did not receive a copy of the complaint until several months. So what?
Yeah, he said it in his affidavit that he didn't.
So what?
So he did receive it. So he did receive it then, Steve. It's really easy.
I don't.
That's what your evidence should be, is here is the proof that Mr. Curtis did receive the documents.
No, well, forget about that. Here's the proof that he was served properly.
Yeah.
That's what you need to show. Damn whether he got the documents. Here's the proof he was served properly. I don't know. I'm trying to give him the best possible light here, bro.
I think they're still playing this whole presumption of service thing. The Kyle has failed in their mind to overturn the presumption of service.
Maybe. Now, pursuant to Emergency Directive 5, affirmative penalty of perjury, that the foregoing representations are true, August 31st, so I will assume they're true. Stephen, his signature is like shit, though. Damn. Oof. This is his script. It's like, come on, you got to do better than that, bro. And they served it to Scotty Forbes. So we've read through these 5 pages of whatever. I don't know. What do you think? Are you guys? Was this secret evidence convincing to you? Let me know. Come on, Agrippa, hit me with it.
No, I can't. I just don't see. I just for the simple matter is this is a technical foul type issue. This is like you've scored a great touchdown. Fantastic. The crowd's gone wild. Wow, fantastic. The scoreboard's ticked over. The video ref's gone, you just touched the sideline on the way through, mate. Sorry, no try. No touchdown. It's a technical foul. Everything was right. Everything was great. The fantastic movement. The quarterback did the best pass.
No, but you know what? What they're arguing is that the defender still tried to tackle him, even though he stepped out of bounds. The defender still tried to tackle him before he made so he knew that he didn't step out of bounds, right?
So I just see it as an issue of I struggle to see how the judge can possibly get past the technicality. Forget the arguments, forget all the secret evidence, forget all that stuff. This is a technical foul still. And I've yet to see anything that has come out of Steve's side that supports anything more than that pulls apart the fact that Kyle's got evidence that shows he wasn't residing at that address.
Yeah, see that. Well, first let me get this $2 super chat. Who's writing these, Steve or his lawyer? To be honest with you, at this point, well, I'm assuming Steve's lawyer wrote this and then had Steve sign it, but who knows? Who really knows? I'm going to say this. The argument here for all you, the legal technicality of service, right, is one that is critical to any litigation in the civil context, because it's both. It has 2 steps. One, it is a constitutional standard, right? It's about you having due process, an opportunity to be heard, and to be able to defend yourself against a lawsuit. So that's why service is important. Service is a part where the court has to notify you that you are in jeopardy of losing money and property, and you now have to defend yourself in court. That's the issue. And the rules are so technical about it because the court wants to say, we know for a fact that you got the papers and you had enough time to respond, right? So it's the 2 things. Not only did you get it, but you also have enough time to respond to defend yourself. Now, in this case, Steve is arguing it's okay we sent this to the wrong address because he eventually got the papers. But that violates that principle of actually knowing that he got the papers, because right now you don't know. Steve is saying we believe he got the papers eventually. He's saying he got them eventually to some point in time. When, who knows, right? Did he have enough time did he get them on the last day? Did he have the proper time to respond? That's why service of process. And 99% of the time when you have these issues, the court's just going to say, well, hey, if you didn't do it the right way, you got to start it again.
Yeah.
That's generally the way it works. So I'm not sure any of this moves that needle for that, because even if all this is true, you still sent it to the wrong address. The place where he now shows through documentary evidence that he did not live. How do you get over that?
I don't think so. I noticed Drag made a comment earlier on, and it's one that I've held for a while.
Mm-hmm.
I think I said to you at the start of this, before the show started, I don't think any of this has got anything to do with the actual law court anymore, or the actual case. This is, and Drag's words are probably more succinctly, this is trying to win the court of public opinion.
Yeah.
This is targeting Steve's supporters, not targeting the judge, not targeting anyone else. Okay, it's being filed at a court, maybe, but this just seems to be a push to sort of say, hey, we're going to get knocked out, therefore, these are the reasons. Kyle lied. Kyle already said it. Hey, it's a technical foul. We've been overturned by a technical foul because Kyle lied, is what I think what the story is going to be.
Well, Hannah Zubby, I'll say Hannah Zubby. Nate, his mom could have called him and told him, hey, you got some papers here. Then several months later, he obtained the papers. Yeah, that's reasonable, right? He's not like, I go to my mom's every day. I go, a couple of times a month, maybe. Nate, the lawyer for Fiona, going to repeat this. Their rule focused on Kyle knowing about it, and they've lost sight of the fact that only proper service gives the court jurisdiction over Kyle, and that's true. And that's what I was saying before.
Yeah.
Proper service forces Kyle to show up, right? He now has to show up under, that's a legal process, and the reason why you have to show up because we've served you properly. And if you don't serve us properly, you don't. Their argument is it doesn't matter that we didn't serve him properly because he didn't show up, and he knew he should have shown up, but he did. But the fact of the matter is, that only matters. Everything they said in this document only matters if they serve them properly. If they serve them properly, then all this stuff does matter, right? If you didn't serve them properly, why does it matter? Because that's the issue. Minister Sobriety. Nate, the lawyer, hearsay and legal arguments in the affidavit. What's wrong with these guys? Yes, you're not supposed to have legal arguments in the affidavit. Yeah. You're just supposed to present the evidence. But
matter of process for all of us lay people.
Right.
When we sit here this time next week, whenever it is, and the judge is going through this whole process about service, and he reaches the point where he says, look, I'm actually going to rule this needs to be set aside and we need to start again. Is there a position then where Steve's lawyer can object to that process or have a say about that? Or is it pretty much now the documents have been submitted, there's not going to be a lot of flapping of gums and other things presented at the hearing? It's basically the judge is going to make a ruling and then advise that the parties, look, this is my ruling.
Well, a couple of things could happen at this next hearing. One, this could just be I hate to say it could just be the judge doing his questioning. Okay, state your case. Because first Kyle's going to have to go on. All right, this, explain. Well, Kyle's attorney is going to hopefully explain it. This would happen, blah, 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 right? And I'm assuming Scotty, his lawyer, is going to be very technical. Here it is. Yeah. It's all a technical issue because when you're an attorney, and when you're in these legal battles, if you have the law on your side, you argue the law, right?
Yeah.
So Kyle has the law on his side. Sent to the wrong address. Here's all the documents to show I didn't live there. And here's what the law says, right? My mom wasn't an agent, blah, 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 blah. So he has the law on his side. So he's arguing the law. Steve has the facts on his side. And that's what this affidavit is trying to illustrate. I have good facts on my side. He said he wasn't going to show up. He said he made a mistake. He said it wasn't my fault. He said all these things, right? But the problem is that even if all that is true, the law is not on his side. Yeah. So it seems like he's trying to overcome the aspect of the law not being on my side by saying, well, I have all these good facts, and these facts should convince the judge that the law that to overcome these legal issues. But I don't think it does.
No. It does. Well, which comes back to, I guess, our scratching of heads and shaking of forelocks is the amount of time that seems to have gone on from people like Steve and Ruhif and Intrigue Feline to deep dive on the legal case studies and principles of law and all this stuff to get to this point. Fucking drag. It just seems to me that this is now just more about winning a debate. It's almost debate tactics, where you come down to who's got the most facts, not the law. And that seems to be the way it's being run by Steve and stuff in Twitter and on videos, etc., etc. It's all about winning a debate type tactics. Forget the law.
Geekaroo for one. Bung up chocolate. Well, you're right. I don't think they're making this document. I don't think was for the court. I think it's more for us. Right?
Yeah,
it's for us. It's for the chest beating. Oh, look, we've given all this evidence. It's clear Kyle got the documents, and I think it's doing two things. On one side, it's playing to the ignorance of the audience. Right, the audience is going to be ignorant, and they're going to say, and if you're just trying to be fair, you'd say, well, if Kyle got the documents, why the hell didn't he show up to court? If Kyle eventually knew that he was being sued, why didn't he just go and fight it then? Why did he do this? So it gives him that, he's clutching those pearls saying, Kyle's a bad guy. He admitted that he didn't go, look at everything I put in this document. But those people won't understand that doesn't matter because Kyle's only responsibility to show up is if he was served properly. And Steve can't have it both ways. You can't say I didn't serve the guy properly, but eventually he got the papers. It doesn't work that way.
That doesn't make sense. But that's most of the arguments I'm seeing from Steve's camp that where I've engaged is it's the moral and ethical position versus the position in law. And look, morally and ethically, take all the technicalities out. Yeah, Kyle knew what was going on and should have turned up, and he got a default. That's the moral and ethical position, but that's not the position in law.
No. And one thing I also want to mention is that right now, what's his name's argument? Ruhef's argument's a little different. Ruhef's argument is hinging on the mom being an agent rule, right? And it's funny because if you go here, if you go to court here in New York, you hear this all the time, right? Oh, we sent it to his agent. BS, How many times do you think this business court judge who's been in the court over 20 years has heard this agent argument, right? Oh, yeah. We sent it to and that was his agent. How many times has they heard that? So, and how many service issues does this court have? Does it have this court heard? It's probably crazy. But I'm thinking the problem with this case is that Steve's attorney is used to serving businesses, right? And them thinking the Non-Seq show was more or less just a business. And I understand that you're serving an individual. I think that's what threw everything off. Because they like, if the Non-Seq show was a business with an address and all that stuff, you send the certified mail. But they weren't serving a business. They were suing an individual. And by suing this individual, they treated it like a business, not knowing that Kyle, they did know. They knowing that that wasn't Kyle's address. That was not Kyle's address. And one thing I also want to mention is notice how Scotty, how Kyle's attorney never brought up the fact that Steve said that they knew it was the wrong address. They sent it to the wrong address. All that
stayed within the law.
Yeah, and because she's not bringing any of that up. She's just saying, hey. The fact of the matter is they sent it to the wrong address. The fact of the matter is we have evidence to show he didn't live there. And the fact of the matter is the law says that this should be set aside. So they have good facts, but they're saying it's just irrelevant because just as a technical issue, we don't need it. Here it is.
Yeah.
And they're not even arguing. And the other side's not even arguing that they didn't send it to the right address, right? They're not even arguing that.
Which I guess brings me to the point where I poked Glenn whenever it was last week, saying maybe you should look at suing your lawyer, mate. There's more money there. I just saw your anal sphincter twitch then.
Oh my God! You got that's.
Professional indemnity insurance policies will be going up next year.
Oh my God, it was Jackson. The level of professionalism is starkly contrast. Yes, that's true. Between the two attorneys, that is 100% true. I'm not sure Stephen co-feel that this game of popularity somehow extends out of this microcosm. That's true. You know what? Next week, Friday, we'll eventually get to see what the judge is thinking, because that's one thing a hearing does. Because the judge has read all this. Well, probably not the judge. His court lawyer probably has read them all, and she's probably told him this is what it is. Because most of you don't know. I'm trying to explain this as simply as possible. In court, the judge usually doesn't even write the orders, right? The judge doesn't really even do any of that stuff. The orders that you see written aren't written by the judges. They're signed by the judge and they say the opinion of this judge, but they're written by his clerks, and the clerks actually are the ones who research the law. So when these motions come in, the judge is not sitting there reading each one of these things. It's their clerk that reads them all, right? And what the clerk does, when something like this comes in, they'll look at it and then they'll look up the law, and then look up the case law themselves, and then they'll go to the judge and say, "Well, here's what the case law says. Here's what the two sides are arguing," and the judge will then ask the clerk, "Well, what do you think?" And the clerk is usually the one that says, if it's good or if it's bad, and gives the reasons why. And the judge obviously has the last word. So sometimes the judge will say, "No, that's not right," or, "Well, I'm going to go this way." But generally, after a certain amount of time, it's the clerk who then knows the judge and will say, "Yeah, this is bad. Yeah, this is good. Yeah, this is bad." So that's where I think Scotty Forbes Lee has the advantage, because she worked for this judge in that capacity. So she's dealt with these things before. oh, do you like it this way? Do you like it this way? Here's the arguments. Here's what the judge likes. That's what I think gives Kyle the advantage in this particular situation. So we'll see on Friday when after the judge now has this, the judge now is going to question him about when you said for Kyle's going to be like, well, why didn't you show up? That's what I'm assuming the judge is going to say. Why didn't you show up? You knew we could have done this 8 months ago. I'm saying you wasted a year's worth of time. Why shouldn't I, let this default stand? His lawyer's got to have an answer for that. Then on Steve's side, well, why the hell did you send it to the wrong address? The guy didn't, what harm is it that's going to be if I let this guy fight the lawsuit?
Well, that was going to be my question for the next follow-up question of what the judge is going to do. Is that a reasonable thing for a judge to say back to the plaintiff, saying, hey, it's quite clear there's been a technical foul here. What harm is there? I mean, I don't think the.
Oh yeah. No. They asked that question.
What harm is there to retrial this? What would be the argument from Steve's side to retrial this?
Money, time. We've got a default judgment in place. He didn't respond. Yeah, there's a lot of heartache, but the judge is going to say, well, so what? You wasted a year. Yeah. There's really no money here. Let's just start. Let's just do it. Let's just do it again. Hell, you sent it to the wrong address. So
yeah,
that's what I'm expecting. But again, there may be some, and I want to make it very clear for everyone out there. Let me read the super chat real quick. Well, I'm gonna read it right after this. This could go either way, right? Because none of us are, especially myself, I am not practicing in North Carolina. Now, I have spoken to some North Carolina attorneys who believe Kyle will win. Matter of fact, every North Carolina attorney who I've spoken to believes Kyle will win. But they, too, are still unsure. Why? Because there may be some procedural thing that they're even missing. So I don't want everybody to think that this is just Steve is automatically won. But I think you have to, the facts are simple, and they're not to be complex. They sent the damn documents to the wrong address. That's it. That's what we're talking about. Can you be served properly when a document is sent to the wrong address? First, I want to take the Timmy S. Thanks for becoming a new member. Thank you. I appreciate it, brother. $5 super chat from Jameson. Haven't seen you around, Jameson 2012. What's going on? You can't be right wing. Your bar card is rainbow color. Also, check up on that I Stand with Sophie case in Texas. Yeah, I'll check up on it. I'll look at it. I haven't seen it. I Stand with Sophie. Tim S. became a member and now hit me with the chat. All right, Nate the lawyer. It's hard to believe a mother would not give her son legal documents. Of course, yeah. On the other hand, it seems Steve is going for a Hail Mary. I think so too. Of course, I think the mom gave him the documents. I honestly think, let's take the best case position for Steve. Let's take the best case position. Let's say they sent it to the mom's house. Day one, right? They sent it to the mom's house. Yay. And then the mom gets it, signs for it, calls Kyle up and says, yo, you got some serious papers right here. Kyle then gets in his car, goes to the mom's house, picks up the papers, and goes home. From everything that I'm reading, based on North Carolina law, that's still improper service.
Yeah.
Why? Because they sent it to the wrong address. And that's if everything happened the same day. That's how I'm understanding it. Even if it all happened that same day, the fact that you sent it to the wrong address, because now if you can show that it was his usual place of abode or something like that, that's different. But if you sent it to the wrong address and he just happens to go show up, or he goes and picks up the papers because they sent it to the wrong address, he was not served properly. Period. That's just the way it goes. Does that make sense?
Very hard to overcome that. It's extremely difficult.
Xavier became a member of a new YouTube member. Thank you, Xavier. Thank you. And I appreciate it, bro. We got a lot of great things coming up. All right. So we get to sit here. Now, is everybody excited for this case next? Because we've been talking about it. We've been seeing paperwork, but now we actually get to see the live arguments. People are excited. I don't know why I'm excited for this case like this. It's like, it's been a year, but
we've had a lot of laughs on this. We've also explored, how businesses should be run and how you should set up a business. We've explored how basic commercial law works at certain areas, things like service, presenting affidavits and the process of all of that. So, as an educational thing for many people, I think it's been a great experience. It's been a bundle of laughs watching the antics. Because, to go back to winning the court of public opinion, at one stage, around this time last year, was it October, November, we had the I won after the default judgment was passed down. Steve owned the internet, didn't he? Owned the airwaves, owned the public, owned everything. And now who does? Kyle's the one having cheeky shots. Kyle's the one getting guest spots. Kyle's the one getting, $5,000 in a matter of days from people. The tide has swung.
Everybody seems to be excited about it. Can't hardly wait. You're right. The tide has swung. I'm both excited and disgusted. Feels weird. Secret Squirrel. I'm excited for this part to be over. Thanks for $5. Secret Squirrel. Oh, all right. For you guys, what's on the screen? This is Judge Gale. This is the person who's making the final decision. And Judge Gale he's a senior judge, so he's been there for a while. He started in 2011. Appointed as special Superior Court judge for complex business in March 2011. So he's been there for 9 years?
Yeah.
So he's chief
judge. Yeah. For 4 years. He served as chief judge of the business
court. Served as chief judge.
4 years.
Oof. So 35 years of experience, commercial litigation, practicing, handling complex business cases. Yeah, so I don't think I don't think this judge is going to be all for the BS. I don't know. I don't think it's going to be hard to fool this judge. This guy's 35 years of experience. This is what he does. He lives with this thing.
Yeah, this is not his first rodeo, and not the first time he's seen something like this come across his desk.
No, absolutely not. Absolutely not. Yeah. Judge Gale. He's the most famous North Carolina judge as of this stream, right? It's been over a year, and how much money do you think Steve and Rue have spent on the lawyer to date? That's a very good question. Ruhev has given some hints. At one point, he said $25,000, and he assumes that if they have to go to trial, they're going to be out another $20,000 to $25,000. So we're in a position, Angry Roach, where Ruhev could spend excess of $50,000 for this case, and that's win or lose. He could lose the case just as good as he wins. So that's what we're looking at. So we're talking about altogether, the lawyers in this case have probably made about what, 30, 40 grand?
30 to 40 grand already.
It's fucking great. Why can't people come to me with cases like this? Why can't you sue people in New York so I can get money like this? This is free money. That's what this is.
You really want Steve as a client?
No, I don't. But I'll take Ruhev's money, $50,000 for this madness,
But you wouldn't have got 50,000, would you?
No, but don't.
You would think about this.
Think about this billable hours. Think about this, because every time the attorney types something up, files something,
7 minutes, isn't it? 6 minutes.
Yes, every 6 minutes. This lawyer, Bill, is billing them look how many filings they have for this particular case.
And the phone conference with Steve McRae. Answered email from Steve McRae.
And then they're going into a goddamn hearing.
Conference to discuss Steve McRae is a complete fucking muppet. 25 minutes. Coffee to discuss, is Steve McRae, did Steve have a crap today? 15 minutes. There you go. I've just done an hour.
Yeah. It's going to, the hearing is going to, because don't forget you're waiting for the hearing, but maybe it's because it's teleconference, because I've gone to court many times, and me going to court, right? Me waiting for the case.
Yeah.
You've got to overrun. Yep. So don't think it just starts and stops at the court. Be preparing for the case, be preparing, because I got to prepare for the hearing. Me and you got to talk before that. Then we got to go and argue in front of the judge. So the billable hours are going to be crazy for this, right? I would love this. I'm like, all right, let's prepare and Steve is calling this guy every day. What's going on? Let's file this. He said this. Can we do this? He says, I speak to my lawyer about all this stuff. So those billables or it's probably through the roof.
He also spoke about the Katie Joy stuff, and he spoke about suing them, and spoke about defamation against Katie Joy and against Kyle and against Mr. Atheist, and he was going to sue everybody. Remember that last year?
He's probably, this lawyer's probably like, thank God we got this fool paying these billables.
This guy's bought a new BMW.
And one thing though, think about this for the lawyer. Now, don't get me wrong, the lawyer's trying to win the case, but it's actually best for the lawyer to lose this.
Oh yeah,
because Ruhef has already said he's going to go to trial. He wants to go to trial. So if they don't win, it's best for the lawyer. Steve and Reds would have Ruhef pay you 33/5 of what they pay their current lawyer. Burger King, baby. Burger King. I'm dragged on. Oh man. Well, that's really that. I think that's more or less it, people. I think at the end of the day, if this case is going, even now at $30,000, right? You might as well just give the money back to Steve.
Yeah, it's just insane.
Why not just give the money to Steve, right?
Yeah.
Steve has probably never seen that much money in his life, And Ruhef has it. It's not like he doesn't have the cash to give him. He has $50,000. I understand Kyle stole from Steve, and I understand that you want to get justice for Steve. I don't blame Ruhef for that at all. But I think at a point in time, you have to understand legally how far can you take this.
Stole? Counselor, that's a bit harsh. Stole?
No, I'm saying that's the argument. That's what he says.
Yeah,
Ruhef, that's exactly what Ruhef says, right?
Yeah, I just don't think it's. I can't see. I struggle with that position. I really do.
Well,
did Kyle act unethically in ending the partnership and dissolving the partnership? Yeah. Mm-hmm. Yeah, I think he did it really poorly.
Well, hold on. I do think a good argument can be made that Kyle stole the money from Steve. 2 reasons. And I hate going back to the secret evidence, but the first thing was Kyle told Steve that he was going to pay him something, right? And they had that whole conversation where he said multiple times,
Yep.
I am going to pay you.
And Shannon Q came out and said the same thing. Do you want your money sent now?
And he said, no, I didn't want the money sent now. So we know that Kyle has money for Steve, allegedly.
In June last year.
Yes.
Not now.
Then Kyle says now that that they never paid him that. He never paid him that money. So you can go to one of two conclusions. Kyle stole the money. Well, he didn't turn it over. Or you can say that because if I'm holding your money and I spend your money and I don't have it anymore, what do you call that?
Well,
if I spent your money, if I have your money, I'm holding your money, I spent your money.
Can I ask what the agreement was? How much I was going to pay you again, Nate? Was it per show, or was it 50% of profits? What was it again?
No, it could be. You're right, and I think even with the financials, and this is the point we were talking about this the other day. Yeah. Even with the financials, I think it's a catch-22 for on both sides. I think it's a catch-22 for Steve. Yeah. Because let's say it's a partnership. Let's say the judge rules it's a partnership and they're 50-50 partners. Then you owe Kyle what $10,000 if those disbursements
numbers are accepted. Yep.
Yeah. You owe him $20,000. But if Steve is a employee,
different kettle of fish,
then that doesn't matter, right? Because and then all those statements about I have your money, you can't just steal an employee's money.
No
matter what the business did, if the business and no matter what the business is losing money, you've got admissions now that you are going to pay the guy. The guy worked, and on top of that, you said you had his money. You can't just steal your employee's money and say I'm not going to give it to you. So he's
in the Kyle's in the Kent Hovind world of not holding taking withholding tax, all sorts of stuff.
It's a clusterfuck. So, but Steve, I think Steve.
So he's a partner.
He doesn't see the forest for the trees. He's going to scream partnership, 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 not knowing that his best. Hey,
I work for the guy.
Yeah. Then the financials don't matter.
Again, though. Okay. Normally, there'd be a bunch of, I don't know what forms you fill in the US, but there's usually a bunch of statutory forms as an employee you have to fill in wherever you are in the world as a PAYG employee that would have withholding tax being held. And I'm assuming America probably is not dissimilar, that even as a sole contractor, that you would have withholding tax. You would hold tax back at a certain level, unless you're a a limited liability company or something like that.
Well,
That you
but
can
just
demonstrate.
well, understand this because a lot of people. What was his name? That's the CPA. He got like 35 years experience.
Peter Riley.
Riley was
Yeah.
saying, which was correct. Riley was saying that this is a tax nightmare, and the reason why tax nightmare is because when those monies were earned 2 or 3 years ago, whenever they were earned, those taxes were supposed to be paid then. You can't go 10, you can't go 4 years later and say, well, because he never gave me the money, the taxes weren't owed in the money. I think Steve, the tax issue was a bomb.
Yeah.
And this whole employment. So I don't know. I would say Steve's best argument is that he was an employee, right? And the argument that he was an employee, I think is a better argument than he was a partner, because the financials don't matter anymore. Now all of that, I was holding your money, I was going to pay you. You can't, when employees are very much well protected within North Carolina, within any state, employees are heavily protected.
Yeah.
You can't take your employees' money and then all of a sudden say, I'm not going to give it to you. But again, I think it's them not seeing the forest for the trees. There's a tree here. The tree is 50-50 partnership. That's his pride. That's not trying to win the lawsuit, right?
Yeah.
Because you got to win. You got an easy win like that.
Well, they wouldn't be doing a lawsuit if they had any sort of brains at all.
But yeah. But that's we had another thing. Elliot says Ruev refuses to pay the judgment that was recently won against him, and a few other partners with him. Nate the lawyer. Okay, I got to check that out. I don't know. I didn't know about any of whether he had a judgment against him or not. Maybe it's something that's going on over there in Australia. I'm unverified. Yes, you caught me live. So So right now it's about time to get out of here, but. Let me know in the comment section before we get out of here. Do you think this was convincing? Was this secret evidence all it was cracked up to be? I want to listen. Have they done anything? Because I don't subscribe to Steve or anything like that.
No, nothing. Radio silence.
Yeah.
Even quiet on. He's still arguing about atheists and rocks and
He's still atheist rocks thing.
Yeah, the usual shit.
I thought that, because usually every time they have something come out, they do a whole, stuff, and look how bad it is. Maybe
not before we went on to air. So that might be one.
They probably know this isn't really like my whole thing is they built up this secret evidence. It was almost like a game show. We got the secret about what's behind the curtain, and then you pull the curtain. It's like there's nothing behind the curtain. I don't know. Well, Secret Squirrel. We're gonna end with Secret Squirrel. There's a few times that he was offered the money, but he wanted to be paid in perpetuity and under the table. Let's not forget. Thank you, Secret Girl. And thank you for the 200 people watching. I hope this was worth it. I hope the secret evidence shocked you. Let me know in the comment section whether it changed your mind or not. Did the secret evidence convince you that Kyle was served properly, or did it convince you he was not? Just let me know in the comment section. It's fun. I just so everyone knows, I read every comment. I don't respond to every comment. I read every comment though. So if you write something down there, I will read it. Trina Porter, I just got here and we are just going. Thank you for it. For Agrippa, do you have anything you want to say to the people before we get out of here?
No, I don't think so. I think we've had so many conversations about this bloody court case. We know it more than the judge does at the moment. I think it's going to be interesting to see what happens Friday. It really is.
Well, for all you guys know, Friday, 10 a.m., be here. We are going to watch the shit show go down together. Next week, Friday, September 11th. And Dragnot, I got to beg Dragnot to come because it's his birthday. That'll be
that'll be perfect. Yeah.
Will you be here next week, Friday?
Yeah, I'll be here. Yeah.
All right. So we got
yes.
Dragnot, hopefully, and we'll have a whole bunch of participants just watching the shit show go down. So for Agrippa, who's over here, boom. My name is Nate the Lawyer, and we're going to see you next time. And Trina, the secret, you got to watch it from the beginning. Wait, scroll back, and you'll see what the secret evidence is.